show that Creeley or Levinson had lunch with a judge probably hundreds of times over the years. Expensive restaurants, lots of liquor. They continue having the lunches and the wining and dining. But more than that, they pay for parties for the judge. They pay for other expenses for the judge. And on one very pivotal weekend, Mr. Mata goes fishing with the judge. And they're on the fishing boat, and the judge says, he breaks down, says, I need money for my son's wedding. You got to help me, I need money for my son's wedding. Can you give me $2,000, $3,000? Can you get me that cash? Can you give it to me? Can you find somebody to give it to me? I need the money. And Mr. Mata will testify, mindful of the fact that he had this very important litigation in his courtroom. He gives him the money. Can't remember whether he gave it to him personally or or the judge sent his secretary over to pick it up, but gives him $2,000, $2,500 in cash in an envelope. Now, during the recusal hearing, the judge made a point of saying, I know the standard that I'm to be held to. It's my responsibility as a judge to disclose if there's something that the attorney should ask me to remove myself from the case. Does Judge Porteous disclose at any point during the case while it's under submission that he has solicited cash from one of the lawyers? Does he tell other counsel about it? Of course not. Ultimately, the judge rules and rules in favor of Mr. Mata's client. It's a huge victory for Mr. Mata's client. Writes a lengthy opinion. Mr. Mole, as he knew he would have to, appeals the opinion, and in large part the Court of Appeals reverses. And not only reverses, but in one of the more scathing opinions you'll ever read, accuses Judge Porteous of making up remedies and arguments out of whole cloth. A baseless decision is essentially what the Court of Appeals views of what Judge Porteous has written. The evidence will also show that at the same time that this illicit relationship is going on with Amato and Creeley, it's not the only relationship of its kind going on in the Gretna courthouse, in the state courthouse. Judge Porteous also has a relationship with a bail bonds company run by Louis Marcotte. And with respect to the Marcottes, Louis and his sister Lori, the evidence will show a very similar pattern. The Marcottes taking the judge out to probably over the years dozens, if not hundreds of meals, buying him liquor, more than that, doing repairs on the judge's car, doing repairs at the judge's home. And for his part, the evidence will show that Judge Porteous set bonds in a manner that would maximize the profits to Louis Marcotte and his company. And one would hope that a judge's priority in setting bond would be to ensure the defendant's appearance in court. But the evidence will show here that the Marcottes asked for bonds that would be set at amounts that would benefit him, Mr. Marcotte, and that Judge Porteous was more than willing to comply. And the judge did more for Louis Marcotte. On two separate occasions, he was asked by Mr. Marcotte to expunge the convictions of employees of the bail bonds business who could no longer work, could no longer be licensed to work in the bail bonds business because of their convictions. So Louis Marcotte goes to the judge and says, will you expunge the conviction first of a guy named Jeff Duhan? And the judge does it. And later of another bail bonds employee, Aubrey Wallace, and the judge expunges that conviction too. And interestingly enough, these are two of the bail bonds employees who were doing the work for the judge, doing the car repairs and doing the home repairs. And when the judge takes the federal bench and can no longer set bonds to advantage Louis Marcotte, Judge Porteous helps to recruit a new judge to take his place with the Marcottes, a new state judge named Bodenheimer, who will later go to jail after pleading guilty to a charge almost identical to the conduct here. With respect to the confirmation process, the evidence will show that Judge Porteous knowingly failed to disclose the corrupt nature of these relationships to the FBI and to the Senate. How do we know that the failure to disclose was knowing? How, apart from the obvious fact that he was certainly aware of the cash he got from Creeley and Amato, was aware of the curatorships that were the basis of that. He was aware of the the lunches and the parties they paid for. He was aware of the drinking and the gambling. How, apart from the obvious, do we know that Judge Porteous quite deliberately kept this from the Senate? Well, he tells us so. He tells us and he shows us so. And let me give just one example of how he does that. Louis Marcotte, when he asks him to expunge one of these convictions, the second of the convictions, Aubrey Wallace, he will testify that when he asked Judge Porteous to expunge this conviction, Judge Porteous says, "I will do it, but not right now. I won't do this until after my Senate confirmation. I'm not blowing a lifetime appointment to the bench to do this for you." And that's exactly what happens. He waits until after his Senate confirmation, and just before he's sworn in, to expunge the conviction of Aubrey Wallace. Now, why does he do it precisely then? Well, obviously he doesn't want to do it before the confirmation because he knows this would materially affect his confirmation if he's expunging convictions for this bail bonds company. But why just before he's sworn in? Well, he also knows that the moment he's sworn into the federal bench, he's no longer in a position to expunge a conviction. He can only do that as a state judge. So it has to be exactly then, and in fact, the evidence will show that's exactly when he expunges the conviction. Now, during the confirmation, Judge Porteous is asked by the Senate, is he aware of any unfavorable information that may affect his nomination? And he answers in his written statement under penalty of perjury, "To the best of my knowledge, I do not know of any unfavorable information that may affect my nomination." Now, the defense might object, well, how could he disclose the expungement of Aubrey Wallace's so shrewdly waited until after the confirmation to do it? And the answer is he'd already done it with respect to Jeff Duhan. This was only the second time he did it. But of course, he also knew about all the cash, knew about all the other expenses, and failed to disclose that. And I think there's no question that would have materially not only affected his confirmation, but ended his confirmation. With respect to the bankruptcy, the evidence will show a similar effort to conceal the truth. He begins the bankruptcy process by filing the petition in a phony name, not Porteous, but he picks a name, Ortis. He files the petition in the name Ortis. He opens the post office box so that this first petition won't be associated with him publicly. Now, why does he do this? Why file in a phony name? Well, perhaps it's to avoid certain creditors, or perhaps it's to avoid having the casinos read about his bankruptcy and decline to extend credit markers to him in the future. Or perhaps, as the defense will suggest, it's simply to avoid public embarrassment. But if a man will go to the extreme length of filing a bankruptcy petition in a false name and certify under penalty of perjury that that name is in fact his real name, if he'll go to the length of taking a post office box to conceal that it is his true identity, will he not conceal other information from the Senate in order to obtain a lifetime appointment to the bench? The evidence will show that he would, and that he in fact did. There are numerous other false statements in the bankruptcy proceeding, which we will chronicle later, but Judge Porteous repeatedly violates the bankruptcy judge's order not to incur new debt when he goes to casinos again and again, filling out credit applications, taking out markers, and borrowing from the casino to gamble. As I mentioned at the outset, none of these facts are... In fact, Judge Porteous admits to most of them in the Fifth Circuit. He is asked about the curator monies, and he admits sending the curators, and he admits calling them and getting cash back. He will not call it a kickback, but Judge Porteous does not deny getting the cash after sending the curatorships. When he is asked how much money did he get from Creeley and Amato during the Fifth Circuit proceedings, his answer, "I have no earthly idea. I have no idea." Not I didn't get the money, not I don't know what you're talking about, but in terms of how much, I have no idea. He got cash so often after such a prolonged period of time, he has no idea exactly how much he got for them. Does he admit getting the $2,000 to $3,000 in cash after soliciting it during the pendency of this case, the Liljeburg case, in an envelope? Yes, he admits that too in the Fifth Circuit. He takes issue, strangely enough, with the envelope. He can't remember whether it was a bank envelope or a regular envelope, but he doesn't deny getting an envelope with cash during the pendency of this multi-million-dollar litigation. He doesn't remember whether he got it personally or whether he sent his federal secretary to pick up the cash for him, but he doesn't deny getting the cash. He admits not disclosing the curator money during the recusal hearing. He admits not paying taxes on the cash income that he got from Amato and Creeley. He admits filing his judicial disclosure forms, his federal disclosure forms, and claiming that he had about $30,000 in credit card debt when in fact he had over $180,000 worth of credit card debt. He admits filing his bankruptcy under a false name, saying only it was his lawyer's idea. He admits filling out credit applications with casinos and incurring more debt in the form of markers with those casinos when the bankruptcy order prohibited him from doing so. None of this he denies. Not the lunches, not the parties, not the favors, not the cash, not the false statements, not the expungements, not the split bonds, not the false name. None of this do we expect he has or will deny. So if the facts are largely uncontested, what is the issue here? As I will discuss briefly after Mr. Goodlatte goes through the evidence of these facts in more detail, the issue in this case is largely this. Judge Porteous doesn't believe any of this conduct is wrong. He doesn't believe any of it is unethical or immoral. In his view, it is at best the appearance of impropriety. As the defense states in its statement of the case, the conduct alleged here is, quote, a variety of acts that constitute at most the appearance of impropriety. It is the unanimous view of the House of Representatives that Judge Porteous' conduct was not only wrong, so violative of the public trust that he cannot be allowed to remain on the bench without making a mockery of the court system. I would now like to turn it over to my colleague Bob Goodlatte to go through the evidence in more detail.